Greetings, folks. This is Attorney Sharif Silmi, and I am coming to you live here this afternoon. I want to talk a little bit today about some of the most recent developments as it relates to primarily self-petitions in the employment-based categories. So as many of you out there know, there are two branches, main branches of immigration law that we deal with on a regular basis, one being family-based immigration and the other being employment-based immigration. And our focus here is really on employment-based immigration. And normally what that means is that a company, a US-based company, has determined that they have a need to fill a particular role. However, there are no US citizen workers that meet the qualification of the role. Therefore, they go through a process where they submit some documentation to the US Department of Labor, stating that they're looking for individuals in this particular role. They advertise the job, and then if they're not able to find a US citizen worker, they are certified to file an immigrant petition for a foreign worker that meets that specific qualification. That's the standard way of employment-based immigration. What we tend to see lots of demand for these days are for folks who either have some kind of entrepreneurial aspirations in coming to the US to start businesses, or they are experts or authorities within specific areas of endeavor. And one of those areas that is extremely popular and that the government has indicated there's a great need for right now in the US is semiconductor manufacturing. Semiconductor manufacturing. So you may have heard, and there was an article just recently in the New York Times regarding, a tiny parts, big ripple, and how global chip shortages are hobbling the auto industry. And the main reason for this shortage is the lack of semiconductor manufacturing domestically in the US. So the US is very reliant on foreign manufacturing of semiconductors. And as the technology is developing and automobiles are becoming basically internet devices in a way, that is something that is really going to be an important need for many years to come. So this is not just about the immediate need, it's going to be a consistent need. So I would say those of you who are even on F1 student visas, really looking into semiconductor studies, different aspects of it, so that you can serve in this field is going to be an excellent way to establish yourself in the US. So, individuals with knowledge, experience, expertise in the semiconductor manufacturing are definitely going to be well positioned to self-petition. And the two self-petition categories under the US immigration law are, number one, the EB2 employment-based second category national interest waiver, and the first category EB1A for individuals of extraordinary ability. There is a lot of crossover with respect to these two areas of law. So first, when we think about an EB2 national interest waiver, you're normally required to have a master's degree. If you don't have a master's degree, there's another way around it. My previous videos, I go into lots of detail about how one may qualify for the national interest waiver. So I would refer you back to that. But when we're looking at the area of work that you are involved in, so if you are dealing here with semiconductor manufacturing or any aspect of semiconductor manufacturing, that is going to be an area that is considered of national importance. So when we look at the national interest waiver requirements, one of the main things that you need to demonstrate is that your proposed endeavor, the reason that you are seeking to remain permanently in the United States or seeking to enter the United States, is to undertake some specific proposed endeavor. And that proposed endeavor being related to anything related to semiconductor industry, basically chips, at this point is, red hot, really, really red hot. So, any role within semiconductor manufacturing supply chain will be considered to have to require substantial merit. There's, this is a high skill area, and we are, definitely seeing a huge level of interest and well received petitions. So, and here's, I think, the giving away a little secret here. When we submit a petition, either in an EB1A or a national interest waiver, one of the main things that we are focused on is describing your field of endeavor, the field that you are a part of or that you intend to be a part of. And when we're looking at the semiconductor field, we can look at a specific, narrow niche within that field. So, for example, where one is developing an etching technique to fabricate, for example, batteries that go into the chips, right? You need micro-sized batteries that go into these chips and power them and enable them to work. That is definitely a very, very specific, particular area where one can demonstrate to the government that they are working in an area that is of national interest. And when we talk about the areas between the EB2 national interest waiver and the EB1 extraordinary ability that have kind of commonality, this particular area that you work in an area of national interest is the most important. Because when you look, for example, at the EB1 statutory language, what it talks about is that you are basically going to prospectively benefit the United States, that you are going to bring about future benefit to the US. And that is demonstrated through your work in an area that is intrinsically or naturally beneficial to US interests. And that is best done through business-related contributions. So many people contact me, and they always have this mindset that the only way I can be approved for a national interest waiver or an EB1A is if I am a postdoctoral researcher and that I'm conducting and publishing scholarly work. That is absolutely not the case. That is far from reality. Because when you look at the actual statutory language, how does one demonstrate that they are going to benefit US interests or establish themselves as having sustained a claim, and in the case of national interest waiver, being well positioned to advance the field? It is through what is called an original contribution of major significance to your field. Now, I want to expand on this idea a little bit, because the statute doesn't simply say that I have made an original contribution of major significance. What it actually says is I have made an original business-related or scholarly or artistic or technological contribution of major significance. So that very well may be a business contribution. In fact, it's the first one that is listed. So to think that you need a publication with many citations in order to position yourself as being beneficial to US interests is absolutely not the only way to achieve the self-petition success. So, having this understanding is very, very important. And before I kind of get into it with more details, I want the audience to understand one thing. The US system is still based on country chargeability rules. So what that means is your ability to immigrate to the US is impacted by your country of birth. And this is true regardless of citizenship. For example, one may be a citizen of Canada. However, if they were born in India or China, their country of chargeability will be that country in which they were born. So let's take, for example, India. Then when we look at your ability to immigrate to the US, it's going to be controlled by that chargeability issue. So how that impacts you is if you're born in India, even if you're a citizen, for example, of Canada, you are subject to the country cap based on your country of birth. And right now, there's an enormously long wait time and backlog for individuals born in India and also to a lesser extent, China. So those individuals will more likely, if they are interested in immigrating or acquiring a green card quickly, they need to file in the EB1 category for individuals of extraordinary ability. If you are not born in India or China, even if you are an Indian or Chinese national, but you happen to be born outside, for example, many people from India perhaps were born in, you may be an Indian national, but you were born in the Gulf, for example, in the Emirates or Saudi Arabia. Your chargeability will be related to your country of birth, even though those countries do not provide nationality documents or any kind of travel document to you. So it's a very important point to understand that your chargeability is based on birth. And also your spouse's country of birth, if you're married, will also determine your chargeability date. So if, for example, you are born in India, however, you married an individual who's born in Malaysia, and you can file in the EB2 category, for example, with the national interest waiver, and what's called cross chargeability, meaning you can utilize the birthplace of your spouse in order to file your documentation or your green card application. So this is, really, really important to understand, because that will determine what petition you're interested in filing. So that is really important to understand. I just want to look, we have a question. So somebody obviously has reached out to us regarding EB1 and national interest waiver. We will definitely reach back out to you and really look forward to helping you. If you have any questions regarding your case or the different aspects of the law, we're definitely happy to answer those. So when we're looking at the need for individuals, you need to determine what is your visa availability date. And that is subject to the State Department's visa bulletin. That visa bulletin, is issued on a monthly basis, usually around the 15th to the 20th. And in it, you'll find basically what date you're able to file for your visa based on an approved petition. And this is true of family-based or employment-based. And when you're able, what's called final action dates. So when you're able to actually acquire the visa, or if you're in the United States, when you are able to adjust status. All right. So very, very important that you look into, where your chargeability lies, because that will be important if you're going to self-petition in deciding whether to file under EB2 national interest waiver or an EB1A individual of extraordinary ability. The individuals who are, basically they're wondering why or what is the best route for them. I would say if you are born outside of India and China, your best bet is to file an EB2 national interest waiver, because that is an easier requirement to meet. Take, for example, the main component of the main standard within each visa. On the national interest waiver side, it asks, are you well positioned to advance your field? Versus the EB1A side states, have you achieved sustained acclaim that is recognized in your field of endeavor? Sustained acclaim recognized in your field of endeavor versus are you well positioned to advance your field? That threshold, that idea is one that is an easier bar to reach on the national interest waiver EB2 side than it is on the EB1A side. So if you're looking for a more sure route to a green card and you're looking at both options, you're better off going for a national interest waiver. So that individual who is a in the semiconductor space will be well positioned to advance the field based on having experience and expertise in the manufacturing. So here, where one is in finance and strategy management, they have a master's degree in finance from a U.S. university and 9 years of full experience. I would certainly say that the national interest waiver, depending on, of course, your country of birth and how soon you wish to immigrate to the U.S., would be a more clear path. So that is really where we are looking for. And indeed, someone who has finance and strategy management will be able to articulate a case that is going to be beneficial from an economic perspective to U.S. interests. So, the one thing that I do see that you have 9 years of experience, normally that might be an issue. However, you have mentioned you have a master's degree, so that basically overcomes any lack of experience, because otherwise you need usually 10 years of experience. But because you have a master's degree combined with 9 years of experience, then that will put you on a pathway to a national interest waiver. So certainly it's, please bear with us. Of course, the demand is very high for our services because we take an approach that is unlike most immigration firms. There's a lot of great work happening out there, and people should, look into, who the best individual to help you is. Definitely, contact a licensed attorney that can help you. But what we try to do is we take a uniquely tailored approach to each case. We don't use a checklist and, have a very fast, rapid submission process. We really take our time crafting cases because that allows us to get people who otherwise would not be approved for either a national interest waiver or an EB1A approved. And that does take, a lot of work and time and energy. So, you definitely need to have some patience in that regard. Now, there's another question regarding, how long the government will take to decide a national interest waiver compared to an EB1A case. That's an excellent question. It's another really important point in deciding which kind of case you want to do, because as of right now, the EB1A extraordinary ability cases have the ability to file what's called premium processing. So that premium processing option is $2,500 that is paid to the government. In exchange, they will decide your case within 15 business days. 15 business days. So if you are in a hurry, you want to know exactly where you stand, then you file that premium processing case. Whereas with regard to an EB2 national interest waiver, there is no premium processing option. So what you would be looking at with an EB2 case and national interest waiver is about 8 months. So right now, if we're looking at the processing time, cases that were filed toward the end of November 2020 are now being adjudicated or decided. That's the national interest waiver case. So if you filed in November of 2020, then now we are in May, mid-May, you should be expecting a decision. With respect to the EB1A, you can file, like I mentioned, premium processing, or if you file normal processing without paying the extra $2,500, so you're just paying the normal $700 fee for the I-140, you are looking at about 1 year, about 12 and a half months. So a little bit over a year. So right now they're deciding cases from the end of April 27th. So that means that with respect to an EB1A that is non-premium, you're looking at a little bit over a year. If you're looking at a national interest waiver, the processing time is about 8 months. And in that situation with a national interest waiver, you do not have an option to file premium processing at this time. However, if you are present in the US, okay, you're in the US and you are well qualified for a national interest waiver, what you can do is you can actually apply for a green card at the same time as your submission. So that's called a concurrent filing. You can file your green card application at the same time as your application for a national interest waiver. So that is, something that is very, very useful to people, particularly if, you're on an OPT and that time period. So an OPT is optional practical training for individuals who have completed a course of study in the US. And normally those OPTs end either, 12, 18, or 24 months. And if you have a date that your OPT is going to end and you have not been sponsored by a US-based employer, you may qualify for a national interest waiver and apply for an adjustment of status, an actual green card, at the same time as you file the national interest waiver case. And that will put you in a very good position to be successful and remain in the US without having to leave. So Deepak is asking whether he can file an I-140 and other I-485 forms together. And yes, Deepak, right now, the EB1 category is current for India. So if you are from India and indeed China, and you have filed or you intend to file an EB1A case, we can file your adjustment of status, I-485, I-765, employment authorization document, I-131, travel document, concurrently, all at the same time. And in that case, you probably don't need to do premium processing. So rather than spend the $2,500 on premium processing, you can use that money to file your adjustment of status, which is $1,140 for an adult and an additional $85 for biometrics, which is, them taking your picture and fingerprints. So when we're looking, Deepak, at what the options are and how we file, if you are in a situation where your status is good, for example, if you're on an H-1B visa and you're working in the US and you have a previously approved I-140 in either the EB2 or EB3 category, that means that you can continuously renew your H-1B visa. Therefore, you probably do not need to file your adjustment of status concurrently with your EB1A application, because you're better off just waiting to see what your result is, since you're not that pressed, unless there's other reasons like you're concerned about the employment or there's all kinds of issues. So on an individual basis, your circumstances may be different, but generally speaking, I would say one who is comfortably living in the US on an H-1B visa and is able to continuously renew it should probably file their EB1A case, wait for the result. Even if you do premium processing, it's only going to be 2-3 weeks wait. And then upon being approved for your case, you can file for your adjustment of status. And many people, by the way, particularly those from India, have toward the end of last year, when we witnessed a enormous jump forward in the EB3, the third category employment-based bulletin, they were able to downgrade. So they were in an EB2 situation. They're EB2 skilled employees, usually with a master's degree. And what they did is they downgraded. They went down from EB2 to EB3 so that they could file an adjustment of status. Well, one thing I can tell you is, look, we've been now about 8 months since that opening took place, and none of the individuals who have filed have received green cards. The most that they're getting is an EAD, because the EB3 dates are going to be continuously jumping around, and many large numbers of individuals filed those I-485 based on an EB3 downgrade. So likely that I-485 application is going to be pending for a very long time. Therefore, you may want to look into filing an EB2 national interest waiver, because you can only have one perm application at a time. So if you have downgraded your employment-based petition to EB3, you cannot at the same time have an EB2 perm I-140. If the second category advances faster than the third category, you're going to need to file, or your employer in this case will need to file a new I-140 and put you back into an EB2 situation. And but if you don't want to depend on the employer for that, what you can do is, since you now have an EB3 approved with a pending I-485, you can kind of get an insurance policy for yourself by filing a national interest waiver under EB2, and that will help you if you change jobs, or if the EB2 dates start to advance faster than the EB3 dates. So that's what we're looking at. And so Deepak, thank you for sharing some of your accolades. And I would say that we really need to look more deeply at individual's case. Simply because one has a patent, it doesn't necessarily mean they're going to qualify for EB1A. Let me explain what I mean. So when we look at the qualifications for EB1A, one of the most important ones we look at, which I mentioned earlier, is that you have business-related contributions of major significance. Well, what that means is you have an original business-related contribution of major significance. So in order to prove that, you need to show two things. Number one is originality, right? This is an original business-related contribution. The second thing that you need to demonstrate is significance to the field of endeavor. So when we're thinking about that, we need to decide what is our field. So if Deepak is a software engineer, then, was your patent? That is certainly an original work. So you got that, right? So you have demonstrated originality because you have patented technology or some business contribution, right? So originality has been met. Now we have to focus on whether your original contribution is actually significant, and not significant to your employer, not significant to your department, not significant to your job, whether it is significant to your field of endeavor. And that is why defining your field of endeavor is the most important thing you need to do before embarking on the EB1A journey. You need to specify what your field is. Software engineer is too broad. There's millions of software engineers. So to demonstrate that you've done something significant within the field of software engineering is a massive, threshold to meet. So rather than do that, what we want to do is narrow down your field. Instead of saying I'm a software engineer, maybe I create software applications to advance public sector, database security. Okay, so that becomes a more narrowly tailored field. Even when I was talking about semiconductor manufacturing, that is, again, the hottest field of endeavor that exists right now. Anybody in semiconductor manufacturing needs to contact me. I will find you a way to get in. You are looking at specifying that field. So if you're in semiconductor manufacturing, I'm still going to narrow it down further. I'm going to say, no, actually, the applicant is an expert at creating electrochemical etching techniques to fabricate microporous columnar silicon electrodes utilized in on-chip lithium battery technology. You see that? We just narrowed down the field using technical language and have created a field of endeavor in the US where maybe there's only 300-400 people or 500 people. So that allows us to really, focus your petition. And you really, a lot of people talk about EB1A needing to demonstrate that you're an expert. If you narrow down your field properly, not only can you demonstrate that you are an expert, you can demonstrate that you are an authority. And when you are an authority within the field, then your case is going to be approved. You don't have to worry so much, do I have publications? Do I have a patent? Do I have this? Do I have that? What you need to do is look at where do I stand within the field so that I can demonstrate that I am going to prospectively benefit the US, that I have achieved, sustained a claim that is recognized in my field, and that I'll continue to work within my field of endeavor. So these are the ways that we are able to successfully petition for many people who thought that, they would never be able to achieve an EB1A or a national interest waiver. I think that our track record in this area has been, fully demonstrated. And, we have really changed that narrative regarding, do I need to be a researcher? Do I need to have publications? Well, look, having publications may help, no doubt about it, but you don't need to have publications. What publications, authorship of published articles is one of 10 criteria within the EB1A space. It's not the only criteria. Another criteria says that you have successful commercial box office sales. So does that mean that one who is a rocket scientist but does not have commercial box office sales is not able to apply for EB1A? Well, the same logic applies to somebody who's making business contributions but has not published work. So you can make business-related contributions of major significance. You may perform in a critical or leading role for an organization that requires outstanding achievement of its members. You may have membership, as our friend here, Deepak, mentioned. You may have membership in organizations that require outstanding achievement of their members. You may have reviewed or judged the work of others. So you command a high salary. There are ways that do not necessarily include publications, but if you do have publications, it is, even better. So, I just want to share really quickly as we're, concluding now that we received a recent, approval for an individual who, thought in a million years that he couldn't get approved. In fact, he shared with me that he consulted and interviewed 10 immigration lawyers before, being turned down, and they said he'd have a chance. And then when he spoke to me, I didn't tell him that your case is definitely going to get approved or whatnot, but I did say, look, here's the way that we can get approved. And here's why you may be in a position to file an EB1A. And he went ahead and did so. He said, and I quote, "I choose to move forward with him," meaning Sharif, "because of his in-depth experience in the area and unique insights and winning strategies he shared with me during our initial consultation call. I've worked with several immigration firms throughout my career on various employment visa related issues, including a very well-known immigration firm that my employer retained in 2020 to petition an EB1B. So many people always say, isn't it better to file EB1B? EB1B is so much easier. You have only 2 criteria to meet. But for an EB1B, you need to be a tenure track professor or a researcher. So if you're in a private company and you intend to file an EB1B, you need to demonstrate not that you're an R&D, research and development, but that you are in research, exclusively a research-orientated position. The other point I want to make about EB1B is it requires international recognition, whereas EB1A only requires national recognition. That is a subtlety that a lot of people don't pick up on, and it is one of the reasons why so many people who file for EB1B basically get denied after having met 2 criteria. So you need to meet 2 criteria. For example, you've authored, scholarly work, or you've judged the work of others, or you have scholarly contributions of major significance. However, you did not demonstrate that you are internationally recognized as an expert in your field. Your EB1B will be denied. So it is not always the case that an EB1B is going to be the right or easier route than an EB1A for extraordinary abilities. So this particular individual went with one of the larger renowned firms. They filed his EB1B. It was denied. He came to 10 attorneys, all of whom said they were not able to help him until he came to us, and we were able to create a uniquely tailored approach for his needs. And he goes on to say that Attorney Sharif is highly detail-orientated, systematic, and he not only explained all of the EB1A requirements in detail, but also described what I exactly need to do to satisfy those requirements, and shared his insights on how a USCIS adjudicator would value my petition. That is one of the things I like to do is prior to submitting a case, we want to do our own internal RFE check. We want to check the case before we file it to determine exactly, what the likelihood of success is, and what we're going to achieve. He went on to say, he just is talking about some of the, experiences he had, mentioning that we have passion and commitment, and that we have a reliable and approachable and helpful team, which is, something we're obviously very proud of. Outside of our regular video calls, he continued, I asked them a lot of questions and they got back to me all the time within 24 hours. I can't always promise that. I'll be honest with you. People ask questions. We try to hold regular meetings. And the best way to work, in my view, is through direct sessions. So we have working sessions with clients and building our case to make sure that they will, meet the high standard required for either a national interest waiver or an EB1A. And he mentioned after the petition draft was ready, we went back and forth with them a few times to ensure that our final petition was excellent. And his EB1A petition was filed with premium processing at the Nebraska Service Center in April of 2021 and got approved within 5 days. And he also mentioned that after his EB1A approval, we did an interfiling request. So an interfiling request would be for that category of individuals who have already filed their I-485 based on, for example, an EB3 or an EB2, but they realize that this I-485 is just going to be pending for a very long time. So what we do is, upon receiving the approval of an EB1A, which is current even for India, we do an interfiling request and have the government adjudicate their green card application, their adjustment of status, using the self-petition EB1A I-140. And once you do that, and you have your employment authorization document, you are a free agent. I mean, you can do whatever you want. You don't need to maintain your H-1B status, and your green card will be forthcoming. Murtaza Ali asks, do applicants of EB2 national interest waiver have to file I-140 amendment when job changes? No, you don't. It's a self-petition. So as long as you are continuing to work in your field, your I-140 national interest waiver is approved, it remains personal to you. So for example, one who is from India, they are on an EB2 backlog. They now have a file and get a national interest waiver approved. That I-140 adopts the previous priority date and it remains personal to you. So for example, if you have a priority date from 2012 in EB2, but you are maybe worried about instability within your job or firm, we can file a national interest waiver, have that approval. It will adopt your previous priority date and enable you to do an H-1B transfer, change employers without, not only do you not need to amend, the new employer will never need to file another I-140 because that national interest waiver I-140 is personal to you and remains good regardless of a change in employment, and also remains good if you decide to even wait for your visa availability date outside of the US, which many people are doing. And how many days time limit does EB2 national interest waiver due to layoff or termination? I don't understand the question. So, if you want to reach out to us, 443-329-2929, 443-329-2929. We can schedule a consultation and help you with your particular questions or needs. And again, this session is intended for education purposes. Do not act solely based on the information provided in this video, and do not fail to act solely based on the information provided in this video. And always consult with a experienced and licensed attorney before deciding exactly what you will or will not do with regard to your immigration needs. Thank you so much, everyone. And we hope to be back with you again soon.